Right, so today we're going to be looking at the area of consent. This is known as a general defence because it can generally be argued for particular offences. It's generally most used as a defence to the non-fatal offences. So we've just started looking at what would class as a non-fatal offence, like your assault, battery, ABH and GBH, and this generally will be used as a defence to those. Okay, as you can see from the top though, however, it's never going to be a defence to murder. So consenting to murder is basically euthanasia, and as you are probably aware, we do not currently have that within our UK law. So strictly speaking then, consent isn't actually a defence, because if you're doing something that we would consider a crime, but they've consented to it, then actually it isn't a crime in the first place, okay? Now, as you can see here, then you've got the non-fatal offences in order of importance. So we start with the lesser charge of assault, which is just putting somebody in fear. Battery, which is an application of unlawful force, so touching. ABH is one of the previous two, so an assault or a battery that causes extra hurt or injury. And then you've got your more serious GBH and wounding charges. Now, the defence of consent is always available for assault and battery, okay? So no matter what, you will always be able to argue them for assault and battery. The potential problematic areas then are ABH and GBH. The law of consent could give you a defence to these, but not 100% guaranteed. So really, the main bit of the handout is focusing on those offences and where consent might or might not be relevant. Now, you have got two massive cases on this area, and your two biggest cases are the case of Brown, which you will obviously be aware of, the sadomasochism case, and Attorney General's reference. Now, the reason these two are the most important cases are because they are the cases that laid down when consent will be available for ABH and the GBH offences. So without these two cases, we wouldn't really have any sort of guidance as to when consent will be available. Now, what is the result of the defence of consent? It does provide a full acquittal. So it's really important that you will get this defence, because obviously it does mean the difference between prison and no prison. So, for example, an ABH charge can carry up to 5 years in prison. Well, if you get the defence of consent, obviously you've saved yourself 5 years in prison. What's the main problem, though? Well, actually, there's quite a lot of problems. The biggest is there's no Act of Parliament. So, as you can see, normally you'll have at the top of the page what Act governs that area. There isn't an Act of Parliament on consent, which means it's all judge-made law. It's all common law. Obviously, Brown and AGUF being the bigger two. That's okay, but there is actually some conflicting case law as well that we'll get to later in the handout. So again, you've got a big problem there. Now, as I just sort of scroll down here then, the first thing we need to prove with consent is that the consent you actually give is real consent. So you need to, as a victim, you need to be able to understand the nature and quality of the acts that are going on. All right, so if you can't understand the nature and quality, then you will not be able to give real consent. Now, as it says there, then certain people can't consent in law. So anybody that would lack capacity would potentially not be able to give that full appreciative consent there. So anybody with some form of mental disorder or, like where we've looked at diminished responsibility, some form of AMFs. Victims of offences, so things like fraud, although you are consenting because you don't know at that point it's fraud, again, that's not available. And then, as I've put there, those under duress. So if you've been forced to do something, that isn't consent. There's a difference between being forced and sort of acting out of submission, and a difference between those that will give proper consent. So let's look at some cases then. So we've got Burrell and Harmer first of all. So this was a man who was a tattooist, and he had been charged with Section 47 actual bodily harm. Why? Because he had actually done tattoos on two boys that were aged 12 and 13, completely illegal. He said that the boys had given full consent to the acts that were being committed and that they understood the nature and quality of what went on. Well, obviously, these boys are very, very young, and when we did take this case to court, even though the boys sort of understood what a tattoo was, they didn't really appreciate the risk of infection, how sore it would be, the fact they would have to be cleaning it, the pain that would be involved and the swelling that would be involved. So the courts held that they didn't understand the nature and quality of the act, so there was no real consent. Okay, so yeah, adding at the end of these cases whether there was or was not real consent, and in Brill and Harmer there was no real consent as a result. Okay, now when you actually look at the age of the boys, that's quite a good decision because it's protecting vulnerable victims. Now obviously we don't know the surrounding aspects of this case, but this could have been something that was via duress, we never know, or just the fact that the boys are so young. We need some form of protection there in place. So, rightly so, charged with ABH, and he didn't get the defensive consent. Oleg Boger's quite a landmark case, really. This case told us the difference between submitting out of fear and consent. So, as I filled the facts in for you there, he offered the lift home to two young girls. He raped one in the car, and the other girl that hadn't been raped at that point saw it go on, and she knew that she was obviously going to have the same done to her. So he's tried to have sex with her. She submitted out of fear. So when he's been charged with the rape, he's turned around and said, well, she consented. Well, she didn't consent. She submitted out of fear because she was scared of what you'd do to her if she did not submit. So the courts held that submitting out of fear is not the same as consent. And again, he was convicted. Okay, so again, no real consent there as a result. Now, your final case here is the case of Tabasum. This is a big decision, really, this case, and I will come back to it later on because it has got some more importance to do with the nature and quality test. But just for now, I'll go through the facts of this. I'm not going to sort of pause or anything, so you'll need to stop and start the video as you see fit. I just don't want it to take too long if I should pause for a while. Right, so in this case then, he managed to persuade women to allow him to measure their breasts. He said that this was for a database to do with doctors and cancer. So he had persuaded these women to obviously allow them to get undressed, measure their boobs for this supposed database. Now, obviously, they knew the nature of the act. They knew they were getting undressed to have their boobs measured, but they didn't really understand the quality. They thought it was all because of this database that was going to get used to doctors for cancer, when actually it had nothing to do with that whatsoever. Okay, so even though he's turned around in court and said the women persuaded, there was no real consent. Okay, although they understood the nature, they didn't understand the quality of the act, and because you need both, he was still convicted as a result. Now, obviously, that's really good public policy. You don't want randomers doing things like that and turning up on your doorstep pretending to be doing databases and things like that for doctors, and then you being in a compromising position. So really good decision there. Right, so we've looked at what would class as real consent. Now what we need to do is work out what implied consent would be. Right, so there are situations then within courts where we will suggest that really minor touchings and things like that would automatically be consented to. So if you just imagine you were in the students' union, obviously we've got about 2,000 students, so I can imagine how crowded it gets there sometimes. You're trying to get out, people are trying to get in, there will be a slight bit of barging, as what we would call jostlings, really, jostlings of everyday life. Now, the case of Wilson and Pringle said that jostlings of everyday life were not classed as a criminal offence, they wouldn't be classed as a battery, so they are automatically consented to, basically. And that's what we would suggest. So you wouldn't ever really see a case in court where it would be a sort of a minor touch like that, or even in sort of the law block, when all the classrooms are letting out at the same time, those stares are absolutely horrific. And again, there would be 100 maybe batteries occurring if they never allowed this. So we are allowing jostlings of everyday life. So the actual area of consent is automatically available for assault and battery. The reason for this then, they are so minor. I mean, assault, you're not even touching anybody, okay? And battery is literally application of unlawful force. So the tiniest touch, prod would be classed as a battery. So because they're so minor, the area is automatically consented to. All right. So where we are restricted and we need to have a little bit of more information is from section 47 and above. So this is where Brown and AG Ref come in, because it's these cases that gave us that definitive list of things that would amount to ABH and above, but could potentially be consented to. Right, so how do the courts determine whether to allow the defence then? Basically, the courts are doing a bit of a balancing act. They're looking at the harm that that act would cause to people, and they're also looking at the social use. So they're trying to balance the two, really. If it's something that's going to be really harmful but not good for society, then they're not going to allow the defence. If it's something that's good for society but not a lot of harm would take place, then they would allow the defence. So it's all about balancing those two things, really. So the limits to consent then. Well, there is still some form of limitation on everybody's right to consent. And as I said before, you can't consent to murder. Euthanasia is still a crime, and we'll come to pretty towards the end. So in the leading case of Brown, Lord Mustill, one of the leading judges, said that the maintenance of life is an overriding imperative. So he's basically saying that our human life is really important. So we have to make sure that there are restrictions on where the defence of consent will work. Okay, now Lord Justice Templeman, as you can see down here, I'm just going to scroll it down, he gave the main areas where consent will be allowed. Okay, so contact sports, horseplay, surgery, sexual activity, branding and chastisement. So what he's basically saying is that for all these, when they amount to ABH and above, we potentially will give a defence, but not automatically. All right, it all depends on really the factors within the case and what the guidelines are for first of the area, So all I'm going to do is take you through each area and show you how the defence of consent will work in practice. So if we start with contact sports then, well, obviously things like football, things like rugby, they have contact. That is the point of those games. So you are really sort of expecting, especially like with rugby, it's a little bit more rough than football would be. You would be expecting contact to take place between the players. Okay, now, as long as what occurs on that pitch is anything that would normally occur, then yes, the defence of consent will be available because it's expected. However, what you have to think of is if the injuries are more than what is expected within that game, then unfortunately the defence would not be available and you would be convicted. Okay, what we have to do again is this balancing act. Sports is generally something that is viewed quite high up within society. It has got a massive social use. So what you don't want to do is ban everything or stop people from touching each other, because you'd never get any football players or rugby players at all wanting to play, because every game they would be risking maybe up to a 5-year prison sentence. So this is an area where we do have to sort of use our common sense here and allow it as long as it is with the remit of the game. Now, one in particular is boxing. Boxing is a sport that is obviously very violent, but it is conducted under a set of guidelines. Now, these guidelines are the Queensberry rules. So these dictate things like how many punches you can do at once, any breaks you need, if you've got them on the floor, obviously how long are you allowed to have them on the floor, the fact that we need certain amount of judges, you've got to be wearing gloves, each round is only meant to be about 3 minutes. So the Queensberry rules are these rules that govern boxing, and if your fight is not under the Queensberry rules, it is illegal, therefore consent is not available. If your fight is within the Queensberry rules, then yes, consent is available. All right. Now, this is sort of quite a big area, because if it isn't something that's in the Queensberry rules, you're just having a fight with somebody on the street, let's say on a night out, then that is a street fight, and street fights can never be consented to. So again, you would not get the defence. Okay. So what are the Queensberry rules then? They're the rules governing boxing. And And obviously they're very, very important there because it ensures the safety of the players and it ensures that the game is conducted correctly. Yes, it's got a lot of social use, but we've got to make sure it's done right. Okay, now, in the case of Coney then, the defendants had been involved in a bare-knuckle fist fight. Okay, and there were quite severe injuries to both people, both that would amount to Section 47 and above. Now, interesting point about this case, it wasn't just the defendants that were convicted, the spectators were convicted as well. Why then? Well, obviously, if you're having a bare-knuckle fist fight, it is not a fight that is legalised. So those people that have obviously paid a bit of a cheeky fee to get in there in the first place, they know it's wrong, all right? You know if it's conducted correctly. You know if you've just sort of paying a quick fiver, going through the back door and just sitting down on one of the steps. So because of the fact that this was not conducted under the Queensberry rules, the defence of consent was not available, all right? The consent that they both gave to fight was considered to be invalid. It wasn't real consent as a result. Now, AG Ref is your big case for here then. So this involved a street fight, basically. And AG Ref told us the importance about the fact that street fights cannot be consented to. So there were 17 and 18-year-olds. They had arguments within the street and they decided to settle their argument having a fight, of course. And the victim suffered a bloody nose and bruising, which would have been at least Section 47, if nothing above. Okay, now, apologies, the defendant tried to argue two things. He tried to argue that the victim consented because they both chose to go and fight, and he tried to say that he was actually just defending himself. Okay, now, he did get acquitted, which is why it is Attorney General reference. Whenever you see these cases here, there has generally been an acquittal. So the prosecution or the Attorney General are referring a question to the Court of Appeal because they're not too sure about it. So he was let off and it caused massive controversy as a result. The Court of Appeal clarified that any street fight would never ever be able to be consented to. So if you had a street fight and you were doing those sort of injuries, 47 and above, you would not be able to ever get the defence, okay? And the leading judge there was the Judge Lord Lane, and he was the one that turned around and said, you shouldn't be able to do any form of harm to each other for no good reason, and street fights are no good reason. So unfortunately, he did get let off, but he shouldn't have been let off. All right, so if it's under the Queensberry rules, yes, you'll get a defence. Whereas AG Ref, it wasn't. It was just a normal fight within the street. So unfortunately, it should not be allowed. And in future, it won't be, thanks to this case. Now, with other contact sports then, what we are looking at here is you're trying to distinguish between two particular sort of instances. We're looking at things that would be classed as on the ball, and we're looking at things that would be classed as off the ball. Basically, on the ball is during gameplay before the whistle has been blown. Off the ball is after the whistle has been blown as a result. Okay, so really, if it's off the ball, it's just the same as street fights. You're doing it illegally, no defence is ever going to be available. Okay, so tough. Whereas if it's on the ball, we then need to consider what sort of injury has occurred. Okay, so I've just explained that at that top bit there. It's no different to a normal offence. So Billinghurst then. So in the case of Billinghurst, the defendant punched the victim in an off-the-ball incident. So it was after the game had been played. They were still on the pitch, but he punched him hard enough to fracture his jaw. All right. Now, the original judge was actually really, really lenient. And he turned around and said, well, hang on a minute, rugby is a contact sport. You would expect that players would know this, so they would automatically give consent. Okay. Now, on appeal, we turn around and says, no, actually, that is not what we would be talking about here. This was an off-the-ball incident. So because it was off the ball, the Section 20 charge was upheld, okay? The defence of consent was not available. Now, this ruling that we've created has actually been followed within other cases. So you've got a Canadian case there of Ciccarelli. Okay, now Ciccarelli was involving an ice hockey game, all right, and after the whistle had been blown, so again, an off-the-ball incident, one of the players was a bit angry they weren't winning, and he decided to hit another player with his hockey stick. Okay, now he's hit him over the head 3 times, and again he has been charged there with a non-fatal offence. He has been convicted following the ruling of Billinghurst. It was an off-the-ball incident. Okay, that was something that happened after the whistle had been blown, and to be fair, even if it was during gameplay, you don't expect them to pick the sticks up and whack you around the head with it, so it wouldn't have got the defence regardless. Now, on the ball incidents then, obviously we need to look at what it is that's gone on. If the injury is something that could be well expected within that particular game, then yes, we will stretch the rules and allow the defensive consent. Barnes is your leading case for on the ball, and it's actually quite a good case because it is very relaxed. Okay, so he was convicted of GBH under Section 20 of the Offences Against the Person Act. He basically gave a late and reckless tackle. Well, that's what the prosecution said anyway. His tackle was very late and it was very reckless. And because of that, they thought that he should not be able to get the defensive consent. He said, well, no, my tackle wasn't late, it wasn't reckless, it was fair, and it was during the normal course of the game. And if I did injure, it was only accidental as part of the game, so please give me defence. Okay, now he was originally convicted of Section 20 because of the fact of the injuries that the victim had sustained, but he appealed, saying, well, hang on a minute, it was during gameplay. All right, so basically, there was a misdirection in this case by the trial judge. The trial judge didn't really direct the jury correct. He sort of said, if there is a little bit of a foul, there's automatically no defence, which technically is not right when it comes to contact sports in this area of law. If there is a little bit of a foul, it does not mean you're automatically not getting the defence. We just need to look at it a little bit more in depth. So a referral was made to the Court of Appeal on this particular area, and Lord Wolfe, you'll remember from last year, he was the leading judge here. Now, he set the guidelines as to when you will convict somebody on an on-the-ball incident. He said every case needs to be seen individually, and you need to have a look at what force was used, how was it used, what was the nature that was going on. Okay, so he turned around and basically said, within this case, look, you have to judge every single case individually. If it's a little bit reckless or a little bit more than you would normally assume, we will potentially allow the defence, but obviously if it's a lot, then we're not going to as a result. All right, so he turned around and said, did Lord Wolfe, look, I'm justifying this because realistically accidents do happen, and in the heat of the moment you might do something that you would not normally do, especially if it's like a really important football game. There's lots of money riding on it. You might be 2-1 down. You just want to really score that goal. Okay, so Lord Wolfe turned around and said, hang on a minute, only convict for on-the-ball incidents if it is sufficiently grave, and that is the current guideline, that's the current test. So if you have done something that isn't normally expected, you will only be convicted if it is sufficiently grave. And then he went on to consider more, look, you know, people can claim compensation. As a result, you can get damages. You can ask for them to be sent off for a few games. The criminal courts is not the place for contact sports, is basically what Lord Wolfe was saying. So before the case of Barnes then, so pre-Barnes, anything that was slightly out of gameplay was automatically not available as a defence. So if you did something tiny, but it was outside gameplay, so it was a little bit harsher than it should be, you wouldn't get the defence. Whereas post-Barnes, we're a little bit more relaxed now. We're only convicting you if what you've done is sufficiently grave. So that concludes your first area then, contact sports. So if it's something like boxing that's got the Queensberry rules, if your fight's under that, excellent. If it's not, it will never allow a defence. For other sports, we'll look at whether it was on the ball, off the ball. Off the ball, never get a defence. On the ball, you will, as long as what you're doing isn't classed as grave, isn't classed as serious. So horseplay then. Well, horseplay was another area that the judges in Brown and AG mentioned as a potential area for consent. So as I've put here, society accepts that community life, such as in the playground, might involve a mutual risk of deliberate contact. So it generally is a good defence. Horseplay is basically rough violence between friends. Okay, so like jumping on each other's backs, arm around neck to sort of say hello, but a little bit more tightly. It is classed as horseplay. Now, what you have to consider here, it's a bit of friendly violence, really. It's not something that you would expect to go to the courts. It shouldn't be something that's criminalised. I get why they've put that as a restriction there, saying that it will be okay. But really, it shouldn't even go to the courts in the first place. So what is it? It's friendly violence between friends, but it definitely shouldn't be criminalised. It shouldn't be something that goes to the courts. So you've got two cases here that are picking on the area of horseplay as a result. Okay, now Jones and others, and Aitken and others. So in Jones then, boys were injured having been tossed into the air by their schoolmates. It was a little bit like birthday bumps, I suppose, although it wasn't really for birthdays, they were just chucking up and down in the air. They suffered particular injuries, okay? So these boys had suffered broken arms, ruptured spleens, quite severe injury, to be fair, which was classed by the court amounting to Section 20 offences, all right? So they're charged with Section 20. They turned around and said, well, the boys have done it before. They've allowed us to throw them up and down before, so we just assumed that they would allow us to do it again, okay? And they actually got the defence. So even though I'm sort of saying it shouldn't be criminalised, there's a difference between a little bit of rough horseplay and broken bones and a ruptured spleen. That's severe injury. But because horseplay is allowed, they got the defence. So I'd say it's slightly a little bit too lenient, really. It doesn't really protect your victim, does it, when you're getting that harm, but unfortunately sort of no charge for the defendant. Now, a similar outcome happened in the case of Aitken. So these were members of the RAF. They'd offered a party, like a passing out party. So whenever they've passed all the guidelines and like the exams they need to do, they had a big party. They were all drunk, and when they do sort of pass out, not as in like collapse, but pass out as in they pass the ceremony, they have like an initiation ceremony, which is obviously drunken RAF soldiers messing around and obviously engaging in some horseplay. Okay, what they did was one of the victims was asleep while he was in his fire resistant jacket. So they decided to set it on fire to see obviously what would happen as a result. And because it was a fire resistant jacket, obviously they thought that there would be no harm there as a result. But because of they poured sort of like spirit over the top, because of how severe the fire was, they had basically set him on fire and he was severely burnt. Okay, again, charges amounting to Section 20. So originally we weren't too sure whether we would convict them as a result, but the convictions were quashed because, again, it was considered as horseplay, and horseplay was something that you would be allowed to consent to as long as you genuinely believe they would agree to it. So in both of those cases, the defence was given. Both defendants believed that the victim would have consented. Jones because they'd done it before, and Aitken really because it had happened to other officers, so the defence was given. So quite a small area really, this one, but as long as you're aware that as long as you reasonably believe they will consent to it, you will get the defence for horseplay, which is very, very lenient. Now, another area that's quite a small area is surgery. Basically, whenever you have surgery, whether it's on your toe, your foot, your leg, whatever really, your arm, you will normally sign a consent form. Because you are signing a consent form, obviously you are consenting to the fact they're going to cut you open. So any form of operation, let's say it's a knee operation, they are cutting you open and causing wounding and causing injury. So they are causing ABH and GBH to you, but you are signing a consent form. And because of that, obviously, there will be no sort of comeuppance there on the individuals, unless obviously your doctors are grossly negligent. Now, what if you're in a crash, let's say, so you are unconscious? Well, then it will be down to your next of kin. So for you lot, probably parents who would be having to sign the consent form to go ahead with what operation because of the fact you are unconscious. So small area really, but obviously if you're agreeing to have some form of surgery done, then you can't then turn around and say, well, you committed ABH on me when you took this potentially broken bone and re-healed it, because it wouldn't work. Now, the biggest area of consent is actual sexual activity. Okay, now you have done a little bit with this with Brown. We are sort of distinguishing sexual activity and sadomasochism as two separate things. Okay, now normal sexual activity between two people, obviously, as long as you both say yes, there's no sort of issue there as a result. Okay, now with sexual activity, we have to go to two sort of categories: inadvertent and S&M. Inadvertent is basically accidental injuries during sex. Obviously, we'd hope that that won't happen, but you never know. And sadomasochistic is obviously S&M activities. Now, inadvertent injuries are accidental. So you are causing some form of harm to that individual accidentally. So therefore, you will be able to get the defence as a result. Okay. Now, your case on this area is the case of Slingsby. So the defendant and the victim had met outside a nightclub, and they decided that they could not wait. In the throes of passion, they needed to have sex in the alleyway near the nightclub. Okay. Beautiful as it sounds. Now, during the sexual intercourse, he penetrated her with his hands. The problem was he was wearing a signet ring on his fingers. So while he was penetrating her, he was cutting her insides. So you can imagine the state of the inside of her there. Okay. Now, because of this, she actually, really horrific, she actually suffered from septicemia. She got poisoning because of the fact the ring had obviously ripped her internal parts to shreds, and she ended up dying. So not really a great case, obviously. It's not the last thing you want to be telling people at funeral why your daughter's died. But because of the fact that it was accidental injuries in the throes of passion, he was not convicted of her manslaughter. They said that the crime that he would have committed was consented to, so there was no crime, there was no unlawful act, so we did not bring a manslaughter charge to him. All right, so lucky for him, really, just a terrible case in terms of what's happened. Now, S&M activity is obviously a lot more severe, and you know from the leading precedent of Brown that you can't consent to S&M. So it's important that we sort of get you to understand why that has come about. Now, before we start with the leading precedent of Donovan, what we're going to do first, leading precedent of Brown, what we're going to do first is go through the case of Donovan. Okay. Now, again, this was a case that there was a misdirection. So unfortunately, he got let off when, again, he shouldn't have been. So he whipped and caned a 17-year-old prostitute on her bum, causing her horrific, severe injuries. And he did it for his own sexual pleasure. All right, he did it because he liked it. She needed to go to the doctor. The doctor saw how horrific the injuries were on her bum, a lot of infection. And obviously, he was then charged as a result. He knew she'd been severely beaten. So he was charged with common assault and indecent assault. And he turned around and said, well, hang on a minute, she consented to it, so I should get the defence. Okay. Now, basically there was a misdirection in this case, because the jury should have the job of looking at the case and working out whether there was consent or not, but the judge refused that to the jury. So because of that, as a result, he was misdirected and he was let off. But the leading point, like your key point of law here, is that in the case of Donovan, they said deliberate violence for sexual gratification is not allowed. So deliberately hurting people for your own sexual pleasure will never be allowed as a result. Okay, so really great ruling, but not in the sense that it got let off as a result. But that is sort of the start of where Brown came in, really. So Donovan said if you deliberately hurt people for your own sexual pleasure, you will not be able to get the defence. So then we had Brown come to court in 1994, and obviously these individuals have been committing S&M for quite a long time, 10 years. So they'd done it in somebody's basement, so none of their acts of violence were ever seen in public, but of course they were doing it for sexual gratification. Okay, so they would pour candle wax on genitals, put fish hooks in genitals to pull it. Sort of the interesting point here, no matter what they did to each other, nobody ever required any hospital treatment, which I still find hard to believe, really, but that was how it was. They never needed any doctors, they never needed any medical attention whatsoever. So when the plug's been pulled on these guys, and they've all been charged with ABH and GBH, that was their biggest argument. Look, we all consented, it were in private, and nobody ever needed any medical treatment, so it should be absolutely fine. So you would think. So they're all charged with, obviously, Section 47 and Section 20. They said, you know, look, realistically, we should get the defence as a result. Unfortunately, they didn't. So they tried to appeal to the Court of Appeal. Now, the Court of Appeal agreed with the original trial judge and said, no, you're not getting the defence because it is deliberate violence. So they went to the House of Lords. They managed to get leave to appeal, and they went all the way up to the House of Lords. But the problem was the House of Lords agreed with what had been said previous. So all that money was wasted, really. They turned around and said that you cannot consent to sadomasochism. It is violent. It is sexual motives. It is never going to work. Okay, so as I've put there, Lord Lane said it isn't in the public interest that you should cause harm for no good reason. And they said that, again, S&M is no good reason. So how did the law lords manage to justify their decisions then? To be honest, they were pretty rubbish, their justifications, and I don't really know if they would slide today. So the sort of a few main reasons were as follows then. So the biggest reason was that they wanted to protect society. They wanted to stop society having this sort of cult of violence. They thought that if they allowed this, that they would be allowing sort of the floodgates to open and any violence occur. They also didn't want men to be corrupted. So they thought that allowing this defence would allow the corruption of men, and that this would automatically make every man violent. Well, no, it don't. So again, complete rubbish. And the third one was even worse. They turned around and said they weren't allowing this defence because they didn't want to risk the spread of AIDS. And again, complete no justification there as a result. There was no sort of infliction of any sort of transmission of disease at all over this 10-year period. The House of Lords basically really did not want these men to get this defence, so they came up with every reason possible to not allow it. Now, the only one judge that sort of, well, the main judge anyway, there was two, but the main judge that was in their favour was Lord Mustill, and he turned around and said, although I think it's absolutely horrific what you're doing to each other, it isn't criminal. You're doing it in your own homes, so therefore you should get the defence. So this was decided on a 3-2 split, okay, with Lord Templeman and Lord Lane being two of the leading judges, and then your two sort of dissenting judges. The main one there was Lord Mustill. So, as I've said, no defence. What happened at the European Court of Human Rights? So again, they took it even higher. The European Court of Human Rights turned around and still did not allow a defence. They said that their Article 8 rights, the right to a private life, needed to be interfered with here in order to protect society. So, tough. They thought the health and morals of society was more important, so they were allowed to intervene and mess with your right to a private life. Now, for those of you that are resitting JP, you might be aware of the case of Emmett. So when Brown said S&M was not available with consent, Emmett was the case that followed it. Okay, so during sexual intercourse, he set fire to her boobs and he's placed a plastic bag over her head so she can't breathe very well with it. Severe bruising around the neck. She was in and out of consciousness, as you can imagine, hardly anywhere to breathe. And her boobs were absolutely horrific with ulcers and infection. It was charged with ABH and he turned around and said, yeah, but she's consented to it. I need a defence. We followed the leading precedent in Brown and says, no, you can't get the defence here because it is considered to be sadomasochism. So no defence was available. Okay. Now, what's quite interesting is they turned around and said, although sexual activity, accidental, I suppose, so inadvertent sexual activity can potentially get a defence, S&M can't. But then they actually gave a separate category for tattooing and branding. So they turned around and said tattooing and branding can actually be consented to, which is a bit weird really, because you'd associate branding with S&M, to be fair, but they didn't categorise it separate. So they turned around and said that tattooing and branding is something you can consent to. Obviously with tattooing you've got to understand the nature and quality, so it can't be kids like we've looked in that earlier case. Now, Wilson branded his initials on his wife's bum and she got infected and the doctors decided to take this to the courts, take it to the police. And he was charged with obviously committing those offences against her. Now, because the Oberton and Brown said that you can consent to tattooing and branding, Wilson got the defence and the judges turned round and said that it was not part of their role to get involved really with anything that would be considered between private life of husband and wife. Okay, so they did not convict him as a result. Okay, so they turned around and said Lord Justice Russell was sort of a leading judge. He said that branding is no different to a tattoo. It's not in the public interest. Your husband and wife, you've both consented. We're all right with it. So really controversial in comparison to Brown. It has been suggested by some academics that maybe if Brown involved men and women, they might have got the defence. But obviously it's a little bit, it's not really politically correct to sort of say that, because you, in a way you're suggesting that your top judges were homophobic and you can't really do that in your exam. But you just can sort of bear that in mind. Now, your second to last area then is lawful chastisement. So under the Children Act 2004, any tiny injury that would amount to chastisement, so like smacking the kid's bottom, would be okay, but anything more than that would amount to a serious offence. So this is sort of bringing in like your baby P cases, your Victoria Climbier cases, your sort of abuse cases of children. That is not allowed. Normal chastisement, yes, but anything that would normally amount to more than battery, so anything with bruises really and above, would not be consented to. Now, the final bit of the handout is picking on general principles of consent. So these are three sort of important factors that link to the area. So the first one being fraud, okay? Now, fraud doesn't always stop you getting a defensive consent. It will only stop you getting it if they were not able to consent to the nature and quality of the act, okay? Now, we've looked at nature and quality before at the beginning. This used to be sort of one test. And the problem with this was, if you understood the nature, even if you didn't understand the quality, because you understood the nature, they got the defence. So it was one particular test, and it meant that people would be able to get the defensive consent readily, which wasn't very good. Now, nowadays, we have separated this test for two separate things. So although you might understand the nature, if you don't understand the quality, you will not be giving real consent there. Now, two cases, Richardson and Tabison. So in Richardson, she was a dentist, but she had actually been suspended at that point. She was under investigation, but she still continued to practice. So obviously when the patients realised she shouldn't have been working, she was all charged with 6 counts of actual bodily harm. The problem was, because they understood the nature of the act and they knew they were having work done on the teeth, regardless of the fact that she wasn't she was qualified, but she wasn't registered to work at that point, did not make a difference. So as I've put here, on appeal, her conviction was quashed. There wasn't a mistake to her identity. We knew who she was, and obviously the act that she was committing as a result. She was a dentist. She performed the job of a dentist. Now, if she wasn't a dentist and she tried to mess with your teeth, then her identity would be mistaken. So you might have been able to argue fraud there as a result. But because she was a dentist doing a dentist job, there was no fraud that had taken place. Okay. Now, Tabassum then, obviously it's the same facts as you've just done before. So this one is all about them measuring the women's boobs in order for this fake database. Okay. Now, he was charged with indecent assault, and he turned around and said, yeah, but all these women consented as a result. Now, he did have a degree in medicine, but he had no sort of extra qualifications after. So it's sort of like me saying, oh, I've got a degree in law, so I'm going to be a barrister. Well, no, you've got to go through the proper process. So his argument that although he had a degree was completely invalid. So basically what we did is we separated the nature and quality test. So we said, although they understood the nature, they didn't understand the quality, therefore the defence of consent was not available. Okay, now to be fair, this is now governed under the Sexual Offences Act, so it would be charged under that Act of Parliament anyway, rather than just a normal indecent assault. But back then, it wasn't created, because obviously Sexual Offences Act 2003. Okay, so his appeal was dismissed. He did not get the defence because although they consented to the nature, they didn't consent to the quality of the act. So as I've put there, we've separated the test, which is good because it means we can convict more. As one test, if you understand one aspect, then you're consenting to both. So as 2 separate tests, it makes it easier to get a conviction. Now, your second to last area is informed consent. This is all about diseases, so sexually transmitted diseases, and whether consent would work as a valid defence here. Okay, now basically you have to know what you're consenting to. So if you know they've got a disease, you don't use protection, you get that disease, tough, you've consented. Okay, as a result. Now the old law was really, really harsh. Notice the year though, 1888. So the old law of Clarence then basically said, as long as you consented to have sex, you were consenting to catch anything, even if you did not know about it. So she had intercourse with her husband, okay, and basically she knew that he had gonorrhea, okay. He infected her with it. And he was convicted with Section 47 and Section 20 of the Offences Against the Person Act. He said, look, she's consented as a result. Therefore, his conviction was quashed. Basically, she wasn't aware of the gonorrhea. She was aware of obviously she was having sex with him, but she didn't know that the gonorrhea was there. So when she's caught this, she's obviously got him charged. He said, yeah, but she's had sex. And the court agreed with him. The court said, if you agree to have sexual intercourse, you agree to catch anything. So the defence of consent was available for him. Okay, so very, very controversial case. Now, thankfully, it's been overruled since, but obviously you need to be aware of that. Now, the case of Courier is a Supreme Court case, but it's Supreme Court of Canada. It is a Canadian case, it's not ours, but we've actually used this law currently, and we've got this law today. So this particular man had sex with 2 women. He knew he was HIV positive, okay? And the nurse had warned him, you need to take the right precautions and explain to people that you have intercourse with that you have got HIV. Now, he had sex with them and he didn't. Okay, so he didn't tell them that he had it, and obviously he transmitted the disease across. Now, he tried to say that Clarence was the law that should be followed, that because they agreed to have sex, it didn't matter that he didn't tell them. Basically, all that mattered was that they consented, so he got a defence. That is not how it worked. So in the Supreme Court of Canada, the leading judges turn around and says, no, you have a duty to inform. So you have to tell them that you have it. Then if they choose to have sex, then it's their fault. But you have got that duty to tell them in the first place. So he was convicted. All right. Now, that was a Canadian case, but we followed it in our case of DICA. So DICA 2005 is our leading case on consent and diseases. So he had unprotected sex with 2 women. They consented to the intercourse, but they did not know that it was HIV positive. They both got the disease, and they both tried to charge him with GBH. He said they both consented. They said otherwise, and they both said, well, if I'd have known about it, I wouldn't have had sex with him. We followed the Supreme Court of Canada, so it was persuasive precedent, and we made it into our UK law that he had a duty to tell them, and because he didn't, he was convicted as a result. Okay, so massive piece of law there that we have got on the area of consent and diseases. Now, Konzani was only decided a year later from DICA, but it followed the precedent of DICA. So again, you've got sort of a binding precedent situation here. Now, he had had sex with 3 people, and again, the defence wasn't available following DICA. He'd contracted diseases to all 3 of them, and we said he had a duty to inform them, and not informing them was why he wasn't going to get that defence. Now, in the case of Konzani, the judge referred to something called the little bird scenario, which basically means if, while having sex, a bird flew through the window, whispered into your ear, they have got HIV. If you stopped having sex at that moment in time, then you're not consenting. But if you continued, then you are. So he basically just talked about this issue of consent and sex, relating it to a little bird. But really, it followed the precedent from DICA, no defence available at all. So he was convicted. Now, we have still got uncertainties. We don't know what would happen if he didn't know, or she didn't know they had the disease and they passed it on. Could they be still convicted there as a result? Realistically, we're sort of waiting for your bigger cases on that as a result. Now, there is a case that you will do in special study called Golding, and this was a particular man who he didn't really know at that particular point that he did have the disease when he slept with her. So we will come back to that when we look at the non-fatal offences. Lastly then, what if you make a mistake? So if you think they're consenting but they're not, as long as that mistake is a genuine mistake, you will get the defence. Basically, that is using your precedent of Jones or your precedent of Aitken, both horseplay cases. They genuinely believe they would have consented even though they didn't, because one were asleep and obviously the others didn't want to do it. It will be a defence. Now, finally then, is your case of Pretty. Pretty suffered really severe motor neurone disease, and basically she was paralysed from the neck down. She wanted her husband to be able to euthanize her and not go to prison for murder. Okay, now this is still within Parliament. It's a massive piece of legislation, and I'm not quite sure it will actually ever get the royal assent, really. The general ruling from the case of Pretty is that although obviously she is going through severe trauma there, human life is more imperative. And the European Court of Human Rights in Pretty turned around and said, we don't care really about this situation because you have the right to live, but you don't have the right to die. So they did not allow this to occur. So unfortunately, she did have to die a painful death as a result. So she tried it all in our domestic courts, it failed. She tried it at the European Court of Human Rights, but they said we need to protect vulnerable people. If we allow her to do it, everybody else will, and people might say yes because they think they're a burden, even when actually they're not as a result. So unfortunately, she wouldn't have ever got the defence of consent had he have helped her as a result. Now, the burden of proof for this is actually on the prosecution. You raise consent and say that they consented, but it's the prosecution to disprove. So it's their job to prove that they actually did not consent to the nature and quality of the act. If you get the defence, it will provide you with a full acquittal. So you really need to be certain that they've consented and have enough evidence, because then it means you will be let off. Okay, now that concludes the video on this area. Have another playthrough again if you're not too sure. We will be going over this in lessons. It's just important that you had an awareness of it beforehand, just because we haven't got time to fully teach it. So feel free to use this as much as possible, or speak to your individual teacher, Amy or myself. Okay.